Hi, this is Victor, and I would like to call today's video Unboxing Discovery. I've seen unboxing the iPhone, unboxing drones, unboxing many things, and today we're going to unbox Discovery in a real criminal case. The client in this case is in custody in Laredo, and he has demanded a copy of his Discovery. He wants a full copy of his Discovery. His family has also called and requested a full copy of the Discovery, and we're going to unbox it and see how much we can legally give him. So speaking of what we can legally give him, I'd like to start with the basic Discovery Statute 1054.2, which prohibits members of the defense team from giving a defendant, his family, or friends the phone numbers or the addresses of witnesses or victims. Other statutes protect information such as driver's license numbers, social security numbers, medical records. So let's get right to unboxing this Discovery. Okay. I have a big stack of paper. Let's take a look at it. And I see that this paper says San Joaquin Community Hospital Emergency Department Summary. And I look through, and every bit of this, all of this are medical records. And we can't give this to the defendant or the defendant's family for many reasons. It has address, phone number, social security number, birthday. None of this is allowed. We can't give this to the defendant or the defendant's family. And we also can't give it to the defendant or the defendant's family because it's medical records, which are protected by HIPAA and other such laws. Next, we have another envelope, an envelope within an envelope. Let's see what is in the envelope within the envelope. And it is an envelope. Well, not really an envelope, a sealed package. It is a, look at that, they even stapled it back in the package. It is a USB drive. I don't know what's on the USB drive, but I assume that it has some video, it has some audio, it may have some reports. We may be able to print out some of the reports and give it to the defendant, but not reports that contain information that I've discussed before. And here's another USB drive, and another USB drive, and another USB drive. So if we sent these USB drives to the defendant who's demanded full discovery in jail, he can't look at them anyway. The defendant doesn't have access to a computer in jail, so these drives would be useless to him. So at best, out of this Discovery envelope, I may be able to print some portions from the USB drives, but there's nothing in this basic Discovery that I can legally give to the defendant. Speaking of printing out the reports, if I print out the reports, I have to redact them. I have to go through and black out anything that is protected by statute, anything that is protected by case law. And that is a long process sometimes in some cases, and often I am not authorized enough funds to do that, and the attorney may not be authorized enough funds to do that. So, and even if we were authorized the funds, a lot of the records really aren't going to do any good for the defendant to read. It's just kind of a waste of time for defendants to demand full access to all their discovery because we can't give it to them, and even if they get it, which I'll discuss in another video, there's not a lot they can do with it. Please like, share, and spread the word about kernseminars.com, where we offer information on free seminars to help litigants, and properkits.com, where we give free forms, free advice, free help for people involved in the criminal justice and the court system. Thank you.